who is here to assist us with our technical things and to help us out. She was gracious enough to host us this evening. Also, I'd like to introduce Kate Rao, Rob Barron, and Chris Ruppow, who are our current officers, and Joe Cardamuccio, who is our past president. What we typically do is we go around to introduce ourselves, just so that everyone knows a little bit about who we are. But before we get started with that, I would like to recognize the passing of one of our long-term LERA members. Tom Crapshow just recently passed away. He was a long-term member of the Central Pennsylvania LERA group, passed away at the age of 73 just in this past week. But we would like to just have a moment to remember him, and I know some of the members in the group may recall him as well. Okay. And now I'd like to get started here with introductions of some of the folks here. I'm going to wrap back around then to Rob, who will introduce our speakers for us today. But first of all, Deb, if you could go ahead and introduce yourself.
Sure, be happy to. My name is Deborah Wallet. I always used to say wallet, like what you put money in. I am an arbitrator and mediator after about 45 years of experience in the labor law field on both sides. I practice from my home in Mechanicsburg, Pennsylvania.
Very good. Thank you, Deb. Jane, please go ahead.
I'm Jane Rigler. I work as an arbitrator and mediator and live in, as I always say, beautiful Carlisle, Pennsylvania.
Very good. Larry, go ahead, please.
Yes, I'm Larry Cheskowicz. I'm an arbitrator and conciliator out of the Allentown area.
Very good. Tom, go ahead. Thomas Leonard.
Hi, I'm Tom Leonard. I'm an arbitrator and mediator. I live in the city of Harrisburg, Pennsylvania.
Very good. Gary, if you could introduce yourself.
Can you hear me?
Yes, sir.
Hi. Hey, how's everybody doing?
Well,
Just been doing some hearing, just finished one in Columbus, Ohio. Have another one in little town west of Illinois, Chicago. And if anybody's ever heard or presented or heard any government agency cases, I'd appreciate if we could talk offline, because these cases I have coming up are both government agencies and they're very difficult to deal with. But it's nice to see everybody here. Hope everybody's in good health. We're starting to get warm spring weather here in Cincinnati. So that's all I have to say.
very good. And Deandra.
Hello, I'm Deandra Roche. I'm an arbitrator, mediator, and adjunct professor, and I'm joining you from the Washington, D.C. metropolitan area. I'm in Maryland. So this is my first meeting, and I'm looking forward to it. Thank you.
Very good. Let's see, now I know I'm going to get this name wrong. Ezio Borcini.
You'll have to unmute yourself. We went through and muted everyone, so there wasn't interruption.
Thank you so much. My name is Ezio Borcini. I'm an arbitrator in Bethesda, Maryland, and I teach a course in legal ethics at George Washington University Law School.
Very good. Thank you. We have James Cooney.
Yes, good evening. James Cooney from Piscataway, New Jersey. I am an arbitrator and also assistant professor at Rutgers University School of Management and Labor Relations. Nice to join you all.
Very good. Welcome. We have Jay. Jay, please go ahead.
Not even gonna attempt that last name, are you, Mark?
I was scared. When you're scared, admit you're scared. I was scared.
My name is Jake Staska. I work for the Commonwealth of Pennsylvania Office of Administration, represent management. And we are, as many of you know, Commonwealth or a government agency that's very easy to deal with, much different than the type that Gary was just talking about a few minutes ago.
Very good. We have KSM.
Sorry, I had unmuted. I have dogs in the background and didn't want them to disturb everyone. I'm Kathy Speaker McNett. I'm a management side labor and employment attorney with the law firm of Scarlatus Zonarich in downtown Harrisburg. Nice to see you all.
Good to see you. We have M. Saveda.
Like Savita, I work for ASME District Council 13 out of Harrisburg. I represent the union. I am working the grievance and arbitration department as the grievance manager.
Very good. Tom Scott.
Hi, I'm Tom Scott. I'm a partner at Killian and Gephardt and represent labor side, do most of our work for PSEA.
Very well. All right. I think I have run out of names. I apologize. I've run through all the names I can see. Did I miss anyone?
Kate, Joe. Kate Rowe.
Yep, so I'll go ahead. Good evening, everyone. My name is Kate Rowe. I am a shareholder with Strokoff and Cowden. We do primarily plaintiff and labor side, labor and employment relations. I am also going to give a brief, bit of a humble brag that this weekend my husband and I were at the United States Supreme Court for an event on Saturday evening. It was absolutely fabulous. I think a once in a lifetime opportunity to wear a tuxedo. Well, my husband wore a tuxedo. I wore a gown for a gala at the United States Supreme Court with two of the justices there, and it was absolutely wonderful. So still kind of reeling from the joy of that.
Wow.
I know this is not all lawyers, but might as well share it because it is pretty cool.
That's pretty cool.
That is cool.
Who were the justices?
Justice Sotomayor, as well as the Chief Justice. Roberts was there as well, so pretty cool.
Nice. Joe Canamucci, you want to introduce yourself?
Sure. Hi, I'm Joe. I am a staff attorney with PSCA's legal division and out of our Harrisburg office. I did not meet any Supreme Court justices this weekend, so I got outside though on the beautiful Saturday. So did some
that counts for something. And I'm Rob Barron. I'm an arbitrator and mediator based in the Philadelphia area. Mark, you can introduce yourself.
Sure. Mark Holman, and I'm Director of Human Resources for the Susquehanna Township School District, and also currently president of the Central Pennsylvania Lawyer Group.
I think that's everyone. Ready to kick off the presentation, Mark?
Sure. Go ahead, Rob. You can introduce the speakers this evening.
So I want to welcome George Voegele and Jessica Caggiano. George is a member of Cozen O'Connor's Labor and Employment section. He's been advising employers in labor and employment matters for more than 20 years, with a focus on traditional labor matters such as collective bargaining and union management relations, employment litigation, and wage and hour advice and litigation in both public and private sectors. George represents businesses, municipalities, nonprofits, and educational institutions in all aspects of labor and employment law, and he's a frequent speaker on issues involving Pennsylvania's medical marijuana law. Jessica is a partner at the law firm of Willig, Williams, and Davidson. She's a union-side labor lawyer focused on workers' rights. Prior to working for Willig, Williams, and Davidson, she was an in-house counsel at the New York State Public Employees Federation and an associate staff counsel at the Pennsylvania State Education Association. Jessica is a member of the PBA's Medical Marijuana and Hemp Law Committee. She's also a member of the Philadelphia Bar Association, the Pennsylvania Bar Association, and the AFL-CIO's Union Lawyers Alliance. So I want to welcome both of them. They've put together a great presentation for today. Jessica, I think you're going to share your screen for the PowerPoint.
All right. How does that look?
If you could just put it on, it looks fine. It's not on slideshow view, but that's fine.
Okay, great.
All right. I think I'm going to lead us off if I'm not mistaken. And Jessica, if you wanted to pop us to the second slide. Again, my name is George Voegele, and thank you all for having us here this evening to talk about this important issue. It's medical marijuana and marijuana legalization in general are certainly top priorities for certain legislators at this point. Whether you agree with the policy choice or not, I think it's safe to say that medical marijuana is here to stay and recreational is on the way. We're at this point up to 36, by some counts, 37 different states, including, well, not including, but in addition to the District of Columbia, Guam, and Puerto Rico that have all legalized medical marijuana. And all states in our region have medical marijuana laws in place, including, of course, Pennsylvania, New Jersey, Delaware, and Maryland. Of course, we still have this incredible fundamental dilemma, though, with all of these marijuana laws, and that is that marijuana is still officially a Schedule I illegal substance, criminalized under the Federal Controlled Substances Act. It's listed right up there along with other drugs such as heroin and cocaine, and nothing has changed about that at this point. And Schedule I substances are illegal not only to just possess or use, but also to distribute, to prescribe, or to purchase. So we have this continuing fundamental conflict between federal law and the many states that have legalized marijuana, whether for medical or recreational purposes, and that continues. The U.S. Department of Justice has taken a very relaxed position with regard to the enforcement of laws that prohibit the use or possession of medical marijuana. As a practical matter, the feds are still taking a hands-off approach with regard to prosecuting any individuals for possession or use of marijuana today. And the bottom line challenge that you have in dealing with this area of the law is that it remains an illegal substance for federal purposes, which impacts employers' obligations under all sorts of federal laws and Department of Transportation testing, and the Americans with Disabilities Act. So we can advance to the next slide, where we talk about really some of the legislative actions that are going on as we speak and continue to push for decriminalization of marijuana in general, not just medical. Just this past Friday, April 1st, the U.S. House passed a bill that would decriminalize marijuana. It passed by a vote of 220 to 204, with 3 Republicans joining the Democratic majority to get it across the line. The bill not only removed marijuana from the Schedule I prohibition, but it also included provisions that provided for expungement of criminal records for possession of marijuana violations, and resentencing for individuals who were sentenced on various marijuana-related crimes. Now, the prospects for this law in the Senate are not looking great right now. We are in an election year for the Congress. This may not be perceived as a winning issue for some senators. So I'm not anticipating you're going to see a whole lot more activity on it this year. But 2 years ago or 3 years ago, I would have given the chances of this moving through even the House far smaller rates of success. So you never know. This could continue to develop, and we may see the decriminalization of marijuana wholesale within a few years. And of course, there continues to be a significant amount of activity at the state level in this area. And we'll get into some of the details of that. But various representatives and senators have come forward with different bills to try and either decriminalize or change criminal penalties for possession or use of marijuana in order to facilitate its use. All right, Jessica, I think I hand it off to you for a moment now.
Sure. I'm just jumping in here with this nice illustration that I believe Rob found, showing you kind of where we stand throughout the country. And this is obviously changing. So this is a fairly recent map, but you can see in the light green the states with laws on the books, and they may differ from each other, but laws on the books that permit the use of medical marijuana in certain instances. And then, of course, the dark green states are the ones that both do that, as well as allow for some level of recreational marijuana use. And then, of course, the states that are not green at all would be the states that don't have or that don't recognize, right, medical marijuana purposes as lawful and don't have recreational marijuana laws on the books. So we're going to talk a little bit more later about the differences between Pennsylvania's Medical Marijuana Act and maybe some of the other laws in place in other states, just to give you a flavor for how they're different. But this gives you kind of a broad reach picture of where we are. And certainly, I think as a country, the map gets updated every so often and gets a little bit greener. That seems to be the trend.
Yeah, I think that's right. I mean, we're up to, I believe, 18 states now that have some form of recreational marijuana allowed. So that number just keeps continuing to grow. All right, let's talk a little bit about Pennsylvania's medical marijuana law. It was passed back in April of 2016. And you may ask, well, how do you get a medical marijuana certificate or prescription? Well, there is a process that needs to be followed. You do need to be under the care of a physician who's been registered with the Pennsylvania Department of Health to dispense medical marijuana prescriptions. That physician needs to provide a signed certification, and you must have a serious health condition. And these really are serious conditions. The Act actually specifies them. There was an initial round, and then some were added. I think we're up to 23 or 24 different conditions that can qualify for medical marijuana certificates in Pennsylvania. And they include things like cancer, HIV and AIDS, Parkinson's, multiple sclerosis, epilepsy, post-traumatic stress disorder, Crohn's disease, and various anxiety disorders. So these are not, you're not getting a medical marijuana card for a broken arm. These are very serious, in many cases, chronic conditions that individuals suffer from. A patient must apply a patient with one of those conditions must apply to the Department of Health for an identification card, and they can only purchase medical marijuana through an authorized dispensary under the state system. We can move it up to talk about how the Act actually limits the ways in which medical marijuana can be used. It can only be dispensed in certain forms like pills or creams or oils, liquids, tinctures, which are alcohol-based cannabis extracts, or in vaporized forms. Now, when the law was first passed, a lot of folks who were proponents of it really emphasized, well, we want to be clear that the medical marijuana law in Pennsylvania does not allow anybody to smoke marijuana. That's not going to happen. However, just a few years after the law was passed in 2018, the state's Secretary of Health did issue an order allowing dry leaf marijuana and flower forms of medical marijuana to be used, and essentially trusted patients to vaporize it and not to just smoke it. So there are forms of dry leaf available to medical marijuana patients, but that option is limited. All right.
So we wanted to talk a little bit about background and just in terms of the difference between medical marijuana and CBD, and also a little bit about testing. So marijuana consists of a significant number of compounds, but the two that get the most focus are THC and CBD. THC, as I think everyone knows, produces certain psychoactive effects. And it can really be ingested in a number of different ways. George just covered a bunch of them, but the bottom line is you can put it on your skin, you can smoke it, or you can ingest it. And when you ingest it in any of those ways, it will create metabolites, which is basically the THC breaking down in the body and producing, which we'll talk about in a minute, but basically producing a signature, if you will, in terms of the fact that it's been used. And it breaks down differently in the body depending on how it's ingested. If it's smoked, it actually, through the lung blood barrier, will put THC into the bloodstream, and it does that literally within minutes of smoking it. And that THC in the bloodstream, as we'll talk about in a minute, is a measurable thing when a blood test is given. It also will over time break down into metabolites that are stored in the body. On the other hand, if marijuana or THC is ingested through some sort of edible, it breaks down through the liver. And in that case, it does not spike the blood. So while there will be THC in the blood, it's not as high a level as it would be if it was smoked. So those are really the two basic ways of that THC gets into the body. Cannabinoids, CBD, if you will, does not have any psychoactive effect. And if you're taking CBD, whether it's being smoked or ingested or put on the skin, it should not produce a positive drug test. On the other hand, there's not a whole lot of controls over how CBD is produced. And so there is a risk that there may be purity issues with it, and there may be some THC in a CBD product. It would, in theory, be such a small amount that it would be unlikely to produce a positive test, but it is a possibility. Next slide. So there are really two common testing methods, and then two other methods that are a little less common. The first is the one I think most people know, which is a urine test. It's the most common because it's the easiest. However, a urine test does not detect THC. What it detects is the metabolites that break down as a result of ingesting THC, and they can be stored in the body for anywhere, depending on a single incident, from up to 7 days, or if you're a regular user, it can be 30 or more days as it stays in the system. And the distinction and the importance of that is that those metabolites indicate the use of marijuana at some point in the past. They have not or are not connected with someone being under the influence at the time of a positive test. And so that's a critical distinction, because a blood test, which is another common way, particularly in the context of a DUI or accident investigations, will detect THC in the blood. And particularly if it's been smoked. And so once THC is smoked, the quantity of THC in the blood spikes significantly in the first hour or two, such that if someone was, by way of example, thought to be driving under the influence and were given a blood test within, say, an hour of having smoked marijuana, they would show a significant spike of THC in their blood. And there are certain levels at which, depending on state law, you are considered to be under the influence. Some states don't have a level. Some states have a 5 or a 10 nanogram level. But the bottom line is it will show if it spikes that you are arguably under the influence. Those levels drop quickly, and within 2 to 4 hours, they're relatively low levels, still detectable, but relatively low levels. Hair is another way to test. However, THC doesn't, the metabolites of THC don't get into the hair until 3 to 7 days afterwards, after it's been smoked. And it stays in the hair. It can stay in the hair for 90 days, 180 days. You can't wash it out. And so it's not considered to be a particularly accurate way to test because it really can last for so long. The last is saliva testing. There are a lot of studies trying to figure out whether saliva testing is valid. It is used down in some countries. For example, Australia uses saliva testing. But at this point, the jury's really out as to whether or not saliva testing has been identified as a reliable test for THC or metabolites. Next slide.
Okay, so I'm going to talk a little bit about some other pieces of Pennsylvania's Medical Marijuana Act, specifically the parts of it that pertain more specifically to employees and employers. Right. There is an anti-discrimination provision in Pennsylvania's Medical Marijuana Act. It uses some very specific language that an employer cannot discriminate against someone solely on the basis of their status as a certified medical marijuana user or card holder. Right. The fact that, the process that I think George already talked about in an earlier slide, there is an involved process for getting a medical marijuana card in Pennsylvania. Once you have the card, you have some level of protected status. Your employment can't, subject to some limitations that we're going to talk about and some other twists, like the status of federal law. In theory, you couldn't be discharged or have an adverse employment action taken against you solely by virtue of the fact that you have that card holder status. And I think some would argue, right, so the purpose of that being that marijuana, has a certain stigma attached to it, and that there is a value in having an anti-discrimination provision for those that are card holders, right? Among probably other reasons, right, that, that there obviously was found to be some value medically at the state level, even though at the federal level, the government still doesn't recognize any permitted use of marijuana for medical purposes. So what does that mean? We do not have, we have some cases, we went through them as part of preparing for this presentation to see what we had here in Pennsylvania. Despite the law going into effect in 2016, I think that there are still a lot of open questions about how a lot of these provisions are going to be interpreted by courts. I'm going to talk a little bit about what we do know, but, given the wording of the law, I believe that there's, and given the status under federal law, employers that are subject to, certain federal requirements, such as employers that employ employees, for example, that are subject to, federal DOT testing, are still complying with those laws, and those laws still, would not recognize medical marijuana as appropriate. It wouldn't be something that, an employee could say, hey, I have a medical marijuana card pursuant to Pennsylvania law, in those situations where federal law is involved. The disciplining employees for failing a drug test or for being impaired at work due to medical marijuana use. I think there's a little bit of a caveat here that we're going to talk about in certain situations, depending on the nature of the test, right? And given some of the background that Rob just gave about testing and some of the problems with certain types of testing, and whether or not those tests are indicative of actual impairment versus some prior use, perhaps weeks earlier where the employee isn't currently impaired. With those caveats in mind, generally, right, the law and the protection for employees in the law isn't going to protect you, or excuse coming to work while under the influence of marijuana, regardless of whether you have a medical marijuana card, right? The law expressly, I think, permits employers to prohibit possession and use of marijuana at work, regardless of whether or not someone, has a medical marijuana card and has a legitimate and lawful basis to be using medical marijuana. We talked about disciplining employees who are under the influence. Caveat to that, that's even if the employee uses the medical marijuana outside of work, right? I don't think that the law excuses coming to work under the influence. And certainly if there's a demonstration or there's some evidence that the employee's conduct at work has fallen below the standard of care normally accepted for that position, it's going to be called into question, I think, whether or not they're under the influence of the drug. In many ways, it's, even though there's a special law for medical marijuana users here in Pennsylvania, it's a very similar, I think, analysis for the average employer and the average employee when you're dealing with otherwise controlled substances, controlled substance prescriptions, where there are potentially impairment issues for various prescriptions. So just because you have a prescription, for any kind of a controlled substance, doesn't mean that you could, necessarily come to work having taken it in a way that it impacts your ability to do your job safely. So just a note on that as well. There are many open questions with the law. One of the ones we flagged here, maybe for discussion, if George or Rob wants to jump in, regarding zero tolerance policies on illegal drug use. I don't know, George, if you had any thoughts on that, or Rob, if you had any particular thoughts on that.
I think it in looking at this law and its purposes, I think that when it first was passed, a lot of us who were looking at it thought, oh, well, you can still have zero tolerance policies on any illegal drug use. If you have a drug testing policy in your workplace and you want to test people and they test positive, you can still discipline them for it. But I don't know how comfortable I am with that in all instances anymore. I mean, if you have someone who is an administrative assistant, has no safety sensitive functions whatsoever, and they happen to be a medical marijuana cardholder and fail a drug test, is it appropriate or really necessary to enforce a drug-free policy in that regard anymore? And I think the courts are going to continue to grapple with that. It's a difficult issue. I think the law was originally crafted as if an employer would be able to still discipline an employee on that. But I will not be surprised at all if courts disagree with that, or it becomes a more nuanced analysis over time.
Thanks. Thought I'd ask, sorry for putting you on the spot. Thought it
No,
would
that's
get up a
fine.
little bit if I asked
Yeah.
either.
And I think it's important too for everybody to note, this act still does specifically provide that nothing in it requires an employer to do anything that would violate federal law. So it's built with certain protections to accommodate, as Jessica was saying, DOT drivers who are regulated in that regard, and others who have federal requirements that apply to them. So.
Absolutely. I'm going to talk a little bit about some of the, we just talked about the anti-discrimination provision, but then there are in the Act, Section 510, there are a number of prohibitions, right? And I look at them almost like, pretty, in many ways, they're pretty broad exceptions to that anti-discrimination provision. Several of them specifically say, this is not going to be considered an adverse employment action if an employer, restricts someone in this particular type of example. So just to give you a flavor for what these prohibitions look like. They talk about, first and foremost, it doesn't say this here on the slide, but the prohibitions reference patients. A patient may not operate, or a patient may not be in physical control. And I just want to note here that in the definitions of the law, right, a patient is not necessarily defined as a user. It's defined as someone who's gone through the certification process, is a resident of the Commonwealth, and has a serious medical condition such that they were able to get a card. So we're talking about the very card holders that, the anti-discrimination provision is supposed to apply to. And here we see in this part of the law, a number of prohibitions. Patients may not operate or be in physical control of certain things, right? And this is I'm going to talk about this first. this is tied to a specific type of blood test. I think it's the only, or a level on a blood test, I should say. That's the only portion of the law that I'm aware of that applies to, in the employment setting and specifies a level for blood testing that would, permit, a person to be precluded from performing, certain activities. So in these instances where we have chemicals that someone's, dealing with that require them to, have a permit issued by the federal or the state government in order to do that job. That's like a subcategory of people. And then there's a category of people who may work with high voltage electricity or public utilities. For those two groups, the law prohibits a patient from operating or being in physical control of those things while under the influence and with a blood content of more than 10 nanograms of active THC per milliliter of blood in the serum. And you just got a really good overview from Rob. And it helped me because I've been trying to find out for years where this particular 10 nanograms standard in the law comes from, where it derives from. I had never really found an answer before as to why they chose this particular level and for these two, kind of specific types of activities. But with, the information Rob provided regarding the blood test, I think you can see a little bit more where maybe this came from. And I'll note that the law says active, it specifies active THC, 10 nanograms of active THC in the blood. And I hadn't really paid too much attention to that before either, but looking around in advance of doing this presentation, I got a little bit of a nice tutorial on the Colorado Department of Transportation website, because that's an important factor for them who have both medical and recreational use of marijuana, right? When they're dealing with and enforcing their DUI laws, right? It's on the DOT website. Like, this is how we're going to decide whether you're under the influence. We're going to look at your blood and we're going to look for active THC, because that's going to tell us really whether you ingested recently and whether you're under the influence versus an inactive THC showing that might instead indicate that you used the substance, sometime in the past, and perhaps you're not actively under the influence now while you're driving. We'll talk about how Pennsylvania doesn't have that kind of a process in a later slide, but just wanted to note that because the law does reference active THC. In addition, a patient cannot perform any employment duties at heights or in confined spaces while under the influence of medical marijuana. And then I think it's in the next slide, two other fairly broad prohibitions, and specifically giving the employer, being a patient being prohibited by the employer from performing any duty which could result in a public health or safety risk. And as well as that, any task an employer feels or deems life-threatening to either the employee or any of the employees of the employer. And I'm just going to note too that, it says under the influence of medical marijuana throughout this section of the law. The law, unlike how it defines patient and a number of other terms, doesn't, to my knowledge, define under the influence. And I do not believe we have a court decision yet interpreting that, but obviously there are a variety of ways you could view that language. You could view under the influence as a positive test in certain circumstances alone. You could view it as maybe requiring more than that. So that, I think, is somewhat of an open question, although certainly everybody's going to have their own view. I will also note there is one case, and I have it here on the screen, Hack versus PHRA. We have the case site there. It's a Commonwealth Court decision. It's a case that had to do with a nurse who sued under the PHRA and maybe under another law too. She was in a nursing program and wanted a reasonable accommodation for medical marijuana use. She was certified to use it. She had, I think it was IBD or some other condition that qualified her to get the card. And in the course of discussing her claims, and among other things, saying that there was no duty to accommodate either under the Medical Marijuana Act or under the PHRA itself. The court also, was interpreting, some of this safety sensitive prohibition language and noted sort of, potentially dicta. I don't know that it was directly related to the decision, but noted that nurses working in ICUs in that case, would, in the court's view, be working in a safety sensitive position, as that term is used in the medical marijuana law. So not a whole lot of case law on that, but a reference here in this case at least.
Jessica, can I chime in with a point and also a question?
Absolutely.
And one of the things I should have mentioned is that the 10 nanograms, there are studies that have shown that if you ingest marijuana, swallow an edible, that you can be under the influence and produce a blood level below 10 nanograms. So there really is a significant difference when you get into testing, particularly in blood, as to whether or not it's been smoked or ingested. So I wanted to just ask you and George if you could just sort of chime in on CDL, a question. So CDL drivers aside, which are federally regulated, could an employer prohibit a medical marijuana cardholder from operating an employer's vehicle or the employee's own vehicle for company business?
George, you want to go first on that, or do you want me to?
Sure. No, I'm happy to. It's a really interesting question, Rob, and not to jump ahead a little bit, but when we're talking about drivers and operating vehicles, we also have to keep in mind there's another layer to this, because Pennsylvania's criminal code basically provide that if you have just trace amounts of Schedule I controlled substances in your system, that's a DUI. So even if you just have a trace amount under the 10 nanograms or a trace amount of cocaine in your system, you can be found guilty of a DUI in Pennsylvania. So it really creates a conundrum for employers who maybe have a medical marijuana cardholder employee who has a company car assigned to them. Maybe there's a salesperson, or who we know drives their own vehicle between customer sites while going out and doing their job duties. Knowing about that prohibition and just general safety concerns, is it appropriate for an employer to allow that individual to operate a company vehicle? To date, I haven't seen a case deciding the issue. I've had a couple clients who've had to grapple with this, and they've come down on both sides of the issue. And of course, the issue could be more pronounced when you're talking about your own company's vehicles. But so far, I haven't seen it litigated out, at least to a decision. And I think it's going to be something we're going to have to keep an eye on and see how it develops. Jessica, I don't know if you had anything to add on that.
No, I haven't had that particular issue come up. I deal a lot with people that are employees or workers that are under the DOT's purview, which has its own little set of problems. But I don't disagree that it would be complicated. And putting aside the DUI component, which is another wrinkle that George correctly identified, I think it's, I think until we get some additional guidance, it's an open question in certain respects. Probably on a fact-specific basis, we sort of have to counsel people, a little bit differently, and depending on precisely where they are and what they're doing. So, but I think it's a good segue to the question's a good segue to the next slide, which talks about, how in some other states there are heightened protections for employees who are either lawfully using medical marijuana or whether there's some lawful basis to use recreational marijuana. But for example, right, there's the second bullet point kind of shows what some of these other states have. They don't have this solely on the basis of your cardholder status, anti-discrimination language that we see in Pennsylvania. They have kind of this additional, you can't discriminate based on their status, but you also, can't, for someone who's registered and qualifying and test positive, right? unless they used, possessed, or was impaired by marijuana on the premises or the place of employment or during the hours of employment. You can't discharge them for that either. Sort of an additional layer of protection, and that, quite frankly, if we had, some additional guidance, would make some of the questions and things we're grappling with a little bit easier. And then we just have a note there too, that I think New York has taken the step of barring pre-employment testing for marijuana, other than maybe in limited circumstances or for certain types of jobs. So just gives you a flavor for how it looks in other places, and how each state law, I think, is pretty unique, and depending on which state you're in, the particulars of that law are going to be very important if you have a question like this that comes up. Can an employee sue for violation of medical marijuana? So in Pennsylvania, and we're still kind of early on with the 2016 year, but we've had a number of cases at this point that say yes, that there's an implied private right of action. And that's, the question was really, since it doesn't say that expressly in the law, right? Is this something that if an employee feels an employer has, discriminated against them, is their sole remedy to perhaps go to the State Department of Health and seek enforcement in that respect? And this Palmer case has been circulating for a while, but it went up on appeal to the Superior Court, which held and I think agreed with the Court of Common Pleas that the anti-discrimination and retaliation provisions of the Medical Marijuana Act create an implied private right of action. And so there have been a few other lawsuits. These two other cases listed here are both Eastern District of Pennsylvania cases. So they're federal courts interpreting state law, but they also, in the context of deciding those claims, found that there was, or agreed, I guess, that there was an implied private right of action for the employees who brought claims in those cases pursuant to the Medical Marijuana Act. I don't know that those employees were successful. I think in the one case, the employee was not ultimately successful. And in the other case may still be, the merits of it may still be pending. But the one clear piece, I guess, is that the claims were not dismissed because there was no cause of action under the MMA. They were at least allowed to move forward with them.
And I think the key takeaway from all of that is that each state's medical marijuana law and its employee protections are different. And they really fall into three distinct buckets. The first is they have no employee protections at all. And then the second bucket would be limited protections like Pennsylvania's that says we protect your status as a medical marijuana card holder. And then there's this third bucket of states like Arizona that go beyond that and say, we're not only going to protect your status as a medical marijuana card holder, but we're going to say if you fail a drug test because you're using your medical marijuana, your employer can't fire you for that alone. You have to show some impairment or some other inability to do the job at work. And it's really important to just understand the differences in those state laws. So with that, let's talk about some other contexts where these medical marijuana usage issues are coming up and where arbitrators are going to need to deal with it. Judges, of course, are going to deal with it. Juries are going to need to deal with it in the years ahead. First off, medical marijuana and disability laws. We talked about how basically if you have a medical marijuana card in Pennsylvania, it means that you most likely have some kind of a protected disability as well. So, well, okay, is notice of a medical marijuana use also notice of an underlying disability under the ADA or the PHRA? And I think the answer to that is yes. If you have a medical marijuana card, you almost certainly have a disability under state or federal law. And so in most instances, our advice to clients, companies who are interviewing people is don't even ask about a medical marijuana card. You're only going to learn information that could be problematic for you in hiring employees. Is allowing an employee to use medical marijuana for pain relief or reasonable accommodation under the law? Under federal law, the answer still is no. But more and more states say there can be a duty to accommodate medical marijuana use under their own state disability laws. And so you have to be cognizant of that. The next question is, should employees taking medical marijuana lawfully for disability be allowed to transport or consume it at the workplace? In Pennsylvania, the answer is no. You're not, as an employer, required to allow an employee to bring medical marijuana onto the workplace, to store it there. You can still prohibit use and possession on company property. And are medical marijuana users protected from discrimination or disqualified for protection because marijuana is an illegal drug? Well, yes, but you have to remember that under federal law, you're still protected if you have an addiction to a particular drug, but that doesn't protect illegal drug use. So it's an important distinction. And state courts are saying that they really aren't concerned about that body of federal law. They're really looking at their own legislature's pronouncements and those of their own state courts in deciding what protections employees are entitled to if they're a lawful medical marijuana user. So let's talk about some unemployment considerations. Really, the case law on this and whether or not, if you're fired for failing a drug test or for using medical marijuana, whether you qualify for unemployment benefits, has turned out to be a little more pro-employee than, frankly, I had anticipated originally. We cite two different cases here. Really, in the first, the employee won because the employer, the company, failed to produce evidence of the failed drug test at the unemployment comp hearing. And basically the court said that we're going to hold you to a strict standard here. If you're going to say that someone failed a drug test and that's why you fired them and they're disqualified for benefits, well, you better show up with the drug test. And also the courts and the unemployment comp board of review have been very aggressive in saying, all right, we're going to look closely at your anti-drug policies in your workplace. And in this Pittsburgh Water and Sewer Authority case, the Commonwealth Court ultimately upheld benefits for the employee because the company's policy said that employees could use, quote, prescription, end quote, drugs while at work, so long as it didn't interfere with their ability to do the job. And the court basically held that, well, under state law, medical marijuana is a prescription medication. And so your own policy says you allow this. So we're not going to say that that employee is ineligible for benefits. And this also is important in the workers' compensation context. Because you do have medical providers who are prescribing medical marijuana to individuals who have various workplace injuries in many cases. Pennsylvania's Medical Marijuana Act specifically states that insurers and health plans are not required to pay for medical marijuana for those under receiving workers' compensation benefits. But again, this is really different from state to state. Some states, such as New York and New Jersey, have laws that permit workers' comp reimbursement for medical marijuana use. And several states, such as Florida or Ohio, have laws that specifically prohibit it. Other states, through their court decisions, such as New Mexico, North Carolina, and New Jersey, have all determined that it is appropriate for a workers' comp carrier to have to pay for medical marijuana as part of an injured employee's treatment regime. This creates serious issues too with return to work. I mean, a great example might be the crane operator who is injured on the job, and while they're undergoing treatment, begin using medical marijuana and need to continue with it. Well, they may be cleared to return to work, but then if they come to work with their medical marijuana card and say that they need to use it, are you going to allow that individual to operate a crane? It really can create a lot of issues in safety sensitive positions. So it's important to keep in mind. And I think with that, yeah, we'll talk about the interaction with some other laws now.
Sure. Just very briefly, because I know we're running short on time. In Pennsylvania, a couple of and some fairly recent more recent cases, right? I believe it was June of 2020, the Pennsylvania held that those on probation or parole couldn't be, barred from using medical marijuana as a condition of their probation or parole. George already alluded to, the status of, Pennsylvania's criminal code and DUI laws. Currently, any amount of Schedule I substance in the blood equals DUI. PA State Police would love probably some updating and a little more guidance, right? As probably everyone would, particularly those that are medical marijuana card holders. And then just the last major bullet, just to make sure we have enough time to cover everything. In a more recent case, the Pennsylvania Commonwealth Court found that a county housing authority acted improperly in denying a medical marijuana card holder a Section 8, housing voucher. So, basically saying, the housing authority's position was sort of, well, it's illegal federally, so we're denying it. And the court said, well, you can't just blanket deny it on that basis. You have to have your own, you got to establish your own standards and apply your own standards when you're looking at those types of cases. So these are all sort of outside the employment context, but worth an update in terms of how the law is interacting in other areas. And we have, I think, drug testing issues is also me. Does it, a couple of questions here, and I don't know that they're, necessarily all legal questions. They're more practical questions and looking at the law and the interplay between state law and federal laws, right? And does it make sense for non-legal reasons to perform pre-employment or other or have other drug testing anymore? I personally know that some of the unions that are my clients and that have had to deal with these issues together with employers or negotiate over these types of things. We have had employers come to us and say we don't want to test for the marijuana panel, and often the reason was there's a labor shortage. Sometimes I suspect the reasoning is we don't necessarily want to deal with this issue until or unless it becomes an issue, right? When because if you test positive, a lot of times people will then produce their medical marijuana card, right, during the review process after the drug test results come back. What impact will drug testing have on turnover and ability to attract qualified applicants? Well, I think I just answered that a little bit. The more prevalent it becomes, whether it's for medical purposes or recreational, and now, of course, you also have people that are telecommuting. You've always had people coming over state lines for employment, and now you have a whole bunch of different laws depending on states. You look at where Pennsylvania sits on that map that we looked at earlier. New York and New Jersey have much more protections for employees, more favorable laws for those using medical marijuana. But we also border on some states that have less protections or no protections as compared to Pennsylvania. How do state laws allowing marijuana use impact drug testing provisions in collective bargaining agreements? Well, they can in that they, in that the fact that there is now a state law and there are these issues about, what's prohibited and whether someone's in a safety sensitive position and they either fail a drug test or I find out that they've got a medical marijuana, they have a medical marijuana card. How are we all dealing with that? Because from a collective bargaining perspective, right, the union has both, a duty to the workers and the members of the bargaining unit and whatever their rights may be under the law, and also has a duty to the entire bargaining unit, which obviously involves concerns about workplace safety. So those things do come to a head, and I suspect we grapple with those issues differently depending on the types of jobs we're talking about, the type of employment, and the particular circumstances. So no one size fits all approach, unfortunately. And how do state? Oh,
go ahead, Jessica.
No, if anyone wants to jump in, I can only see 6 people at once, so go right ahead.
No, this is George. I think we were going to turn to some takeaways, and really I was just going to mention as well the practical consideration that I'm finding more and more companies are simply deciding to take marijuana off of their panel testing for new hires or for other situations, because especially if you're in a state with recreational, it becomes very, very difficult to then get qualified candidates to fill various positions. So that's something that we are going to, I think, continue seeing develop. So a couple of takeaways from the presentation, and we're certainly happy to answer some questions, but it's really critical. If nothing else was conveyed here today, I hope that everyone understands that each state's law is unique and different in these various marijuana arenas. There's different employee protections, there's different definitions of what uses are appropriate and what criteria you need to use in deciding whether someone is impaired or can be excluded from certain types of work based upon their status as a medical marijuana user. For the time being, at least, under federal law, marijuana is still an illegal substance. And so it receives different treatment under various federal laws and certainly Department of Transportation testing regimes than it does under various state laws. And it may be very important as a company as these things develop, or for a union to be familiar with its company's policies, to have a say in job descriptions, perhaps, because it may be appropriate in certain instances or for certain jobs to identify the job itself as a safety sensitive job. It may be that the company and even the union may want certain medical marijuana users not to be able to perform certain functions, and clarifying in a job description that's a position is safety sensitive may enable the company and the union to do that in Pennsylvania. For the same reasons, it's important to look at things like work rules and drug testing policies and how they're integrated with a collective bargaining agreement to determine how they may be applied with regard to disciplinary issues or medical testing issues. So as you can see, there's a whole host of issues and topics that the development of medical marijuana law is going to create, and it's going to land in many of your laps as you decide cases in arbitration or act as an advocate in these various matters in the years ahead. So with that, I think if there are any particular questions or issues, we certainly have a few more minutes to spend with you and would be happy to address them. Rob?
Jessica, if you could stop sharing.
Oops. There we go.
So everybody's on mute, so you have to take yourself off mute. But thank you very much for actually start with that. George and Jessica's a great presentation, and I know working with you, I've learned a ton about medical marijuana and the laws associated with it. Questions? As I said, everybody's on mute, so you have to take yourself on mute. But I know we're a little past 7. Go ahead.
This is Jane. I have a question. Is the term employer defined in the Pennsylvania statute? I mean, it includes public, private, no matter the size, those affiliated with religious organizations. Every entity that's an employer is covered or is required to comply with the statute?
That is a great question. I must confess, I don't know the answer off the top of my head. Do either of you?
I do not know the answer off the top of my head. I just pulled up the definitions real quick. I don't see a definition of employer in the definition section. I see a definition of employee that I don't think necessarily answers the question, but that's a good question. I'm happy to look and look a little bit closer and follow up with an email, but unfortunately I don't see it jumping out at me right this moment.
Okay, thanks.
Other questions? Well, I actually have one. I would be interested to know what you're telling your clients on both sides with respect to how to assess whether a job is safety sensitive, because that seems to be a broadly written term, to, I guess, put it mildly. So if you could talk about that a little bit.
Sure. Really, in dealing with it, I think it's kind of a you know it when you see it type of role. You're a forklift operator in the warehouse. You're a crane operator on the construction site. You're I think police officers and firefighters. I think those kinds of roles can certainly be circled as safety sensitive positions, and you'd need to look very closely then at whether there are certain functions that they should not do in those roles, or whether you can even preclude a medical marijuana user from holding the job in the first place. It still is unclear under the law whether you're allowed to do that in Pennsylvania, but I think that was the intent, at least for certain roles. So, you look at the potential harm that if someone is impaired in doing the job, what kind of harms could result, and those kinds of things I think are apparent when you're talking about certain jobs of that nature.
Jessica, anything you want to add to that?
Only that when I do have this issue come up, I'm always hesitant to advise, I guess, that the union just agree or concede on the safety sensitive nature of a position until or unless it knows kind of a bit more. Both, the union's obviously going to know its business, it's going to know the job titles, and it's going to know the job descriptions and the duties of bargaining unit members, but maybe getting a sense too from the bargaining unit as to how big of an issue it is. I look at the express prohibitions in the law. They obviously give us some very specific guidance. You can look at the term safety sensitive is used in other laws. You can look for guidance there as well. I think it's defined in the DOT regs. I mean, you could take a couple of different approaches, but given that we don't have anything giving us more specific guidance, it's a tough question, because what I would hate to see happen is a situation where we agree to, or we advise that a union should agree to a broader set of positions as safety sensitive, and then you get a court ruling or a regulation finally gets developed with a more limited definition, and then we're all stuck with having agreed to something that arguably is more limiting than what people are entitled to under the law. So I know that's sort of like a non-answer, but I have to take it one specific, client specific and job specific and employer and employment specific as I can when I'm looking at that.
Thanks. Any other questions before I turn it back to Mark?
I have a.
Oh, go ahead.
Sure. Yeah, just a quick question. I think it was when one of you was describing the Pittsburgh Water Authority case and basically said marijuana for a card user is treated like a prescription under a drug policy, under the employer's drug policy. Do you find that's generally the case? When I see that medical marijuana law, it almost like it bends over backwards to not use the word prescription. I don't know if there's a healthcare reason for that, but do you find that most employers treat a card holding medical marijuana user, treat it the same as under a policy that talks about being lawfully prescribed something?
My clients have kind of struggled with that when they understand that someone is a medical marijuana user. Many of them want to try and accommodate the individual. They just want to make sure they can do so safely. And so many of them will want to ask the patient whether or not, what dosage they're using and how frequently they're using it, and have they seen any signs of impairment in doing so. And those kinds of questions can be very dicey. And if you do have a policy that provides for, disclosure of other medications that could, such as opiates, that may potentially impact someone's ability to do the job as well, it becomes even more of an issue to try and accommodate it. So I've found that most employers know this is important and don't want to take their responsibilities lightly, and so they will treat a prescription like a prescription, assuming they know the law. They just have the same kind of questions anybody would about perhaps someone who has been prescribed opiates and whether they can still do the job safely given what they'll be taking.
Jessica, anything else you want to add?
I guess just briefly, I've seen it handled that way. I've seen an employer and a union attempt to negotiate something that would, put it in that category or try to incorporate it into an already negotiated policy that deals with prescriptions for controlled substances. And one of the problems that has arisen, and I don't know that this is just, in this particular instance, how it was reported back to me. Some of the employer policies, talk about prescription use being okay under the policy as long as the person is taking it consistent with their prescription and their lawfully prescribed dosages. That's something you can easily get from a doctor or get from a pharmacy for a lot of drugs. But my understanding is not so with medical marijuana prescriptions, that you're not necessarily going to get a specific dosage or an amount that you're authorized to take consistent with your medical marijuana prescription. And so in those instances where you're looking for that kind of a fix, you may have an issue.
Thank you both.
Thank you. Any other questions? Mark?
Very good. We would like to thank you all for a very engaging conversation this evening about medical marijuana. We would like to thank George and Jessica and our own Rob here for taking us through this great presentation. We do thank you for joining us. We also thank all of our guests and participants and members who were joining in on this session as well. And we do look forward to seeing everyone at our next meeting. Our next meeting is scheduled for May the 3rd, and we will be virtual. So you will look out for our announcements for that particular meeting. But thank you all for joining us this evening.
Thank all of you. Have a wonderful evening.
Thanks, everybody.
Thanks again, George and Jessica.
Thank you.
Thank you.
Thank you.